Welcome everybody. I would like to call to order this work session of the Anchorage Assembly. It is Friday, September 17. This is a work session regarding discussion of draft AO for represented AWWU employees and A1 status. We are noticed from 1 to 2 p.m. Let's go ahead and start with introductions. We'll begin with the phone, or actually, since we have, I believe, 5 folks on the phone, Ms. Camacho, would you just go ahead and call roll? Ms. Allard? Mr. Constead?
Here.
Mr. Dunbar?
Here.
Ms. Kennedy?
Here.
Ms. LaFrance? Here. Mr. Peterson?
Present.
Mr. Presberdia? Ms. Quinn Davidson?
Here.
Mr. Rivera?
Present.
Mr. Waddleton? And Ms. Zalatel?
Here.
Thank you, Ms. Camacho. And if we could go ahead and have folks in the room identify themselves as well so people on the phone know who's here.
Patrick Burke.
Blair Christensen, Assistant Municipal Attorney. Raylene Griffith, Labor Relations Director.
Nikki Tabaka, Human Resources Officer.
Brenda Mcguire, Business Agent, Members of the State Federal Team.
Eugene Cohaven, Sub-20 Government Watchdog.
Thank you, Mr. Haberman. And I believe we also have on the phone Dean Gates, Assembly Counsel. Yes? He should be on the phone. Okay. Mr. Dunbar, do you want to go ahead and provide an introduction?
Yes, absolutely. And I talked to Dean. Dean was going to be down here, but the translator wasn't available. So that's why he's upstairs calling in. So there might be a little bit of a delay.
If I can interrupt really quickly, this is Heidi Dragus. I'm counsel for the plumbers and pipe fitters, Local 367. I'm on the line for questions as well.
Thank you, Ms. Dragus. And also, for the record, we've been joined by Mr. Waddleton and Ms. Allard. Mr. Dunbar?
Yeah, thank you. So I guess I'll start with an apology. I'm sorry that, 2 apologies. One, if I had known this was going to be the only work session on a Friday, I might not have pushed for it so that everybody could have started their weekend a little earlier. 2, I apologize that I got this to folks so late. We've been working on this for a little while, and unfortunately, you know, just with the legal office had a lot of stuff sort of blow up this week, and so that's sort of just what happened. But I have a draft ordinance here. There's also a memo that we're working on with a lot of details to it, but it wasn't ready. My intention is, I think our intention, I should say, Mr. Waddleton is also a co-sponsor on this, is to introduce this to the addendum for the 28th meeting, the 28th for introduction, and then obviously the public hearing not till October. So we've still got a lot of time to talk about this. I think we could have another work session if the chair would allow, or even take it up at a committee hearing if someone wanted to take it up at a committee hearing between the 28th and the first meeting in October. You know, ultimately, it's a pretty simple change. And what this does, so by way of introduction, there are 3 sort of service classes amongst our representative employees in Anchorage. And if you go to page 2, you can see them listed there. A1, A2, A3. And you can see services which may not be given up for even the shortest period of time, services which may be interrupted for a limited period of time, but not for an indefinite period of time, and services in which an absent extraordinary services, you know, what it says there. You can have extended periods without serious effects on the public. And I should say that is not new, that's existing code. The only change that we're actually proposing is if you look at subsection B, there's the underlying text there is what's being inserted, and then you can see the deletion. So it's basically 5 new words that are being moved. And what this would do is take the sewer and water employees, represented employees at AWWU, and move them from class A2 to class A1. And what that means is they would no longer be allowed to strike, but they would get what's called binding arbitration. And so binding arbitration is a process in which you go before an arbiter or a mediator. Is it arbiter? Yeah, not a mediator. And then both sides are bound by that decision. In what's happening now, what has happened in the past with AWWU employees, and for those of you who remember, our AWWU negotiations have tended to go very long and be quite contentious. And actually, there's Brandon, if you wanted to speak at some point, Brandon can speak more directly to this. If you want to come and sit up here, Brandon, and to speak to this. But basically, by keeping them at A2, what we've said is you do have the right to strike, and you don't get a binding arbitration. The problem is when our AWWU employees tried to strike 10 years ago, the municipality went to court and got a court order preventing them from striking. And the reason is pretty obvious. We cannot shut down our water utility, even for a moment. And so to me, it's about sort of basic fairness. We are saying they are one kind of employee, and then in our own legal filings, we are treating them like a different kind of employee. And so what we're proposing to do is shift them from A2 to this class A1 category where, like police and fire and emergency medical services, they cannot be allowed to strike, but they also get the right to binding arbitration. And I'm hopeful that this will lead to less contentious labor negotiations, but also, again, just basic acknowledgement of reality. We cannot have our water utility shut down for even a day for reasons that I think are pretty intuitive. So that's it. That's the whole ordinance. I don't know if anybody else wants. John, do you want to speak to this at all?
No, I think you covered it.
Do you have a phone on? Is there a?
There's a loop.
Did you guys I don't know if she did, but Crystal Kennedy's on the phone. She did, okay.
Yes.
Sorry.
Is that my voice coming back through the phone? Yeah, it did.
That was, I just muted, somebody just dialed in, I muted that.
I sound very mechanical on the phone. That's pretty cool.
That's how you actually sound.
Is that right?
Comic book robot.
I gotta work on that. No, I think there is essential fairness issue there on the negotiations. I'd be interested in hearing the administration's viewpoint if they're prepared. And then I also talked to Will Earnhardt, who I think might be on the phone. And he was a city attorney when this came up 10 years ago. And I talked to him today and he had some viewpoints too, just kind of flesh out various issues. But so I don't.
Yeah, absolutely.
Administration and Will maybe. Will, are you here?
Mr. Earnhardt, are you on the phone? Okay, well, perhaps.
Okay, I didn't know. I talked to him this morning. He thought he could make it.
Who would you like, Mr. Waddleton, to speak?
They're both chomping at the bit.
So Patrick Burke, for the record, I have Assistant Municipal Attorney Blair Christensen here, as I'm sure everybody in the room knows that Blair's, I think, one of the best labor attorneys in the state. So we're going to be relying on her for her legal analysis.
I would just note that I saw you shaking your head wildly, so I look forward to it.
So, through the chair, Mr. Waddleton, I think with police and fire services, we could not shut down for even a moment. Because we couldn't, immediately 911 services would shut down, right? Dispatch, all of that stuff would shut down. With AWWU has a emergency plan in place for a strike. And I think we generally anticipate that we could run the wastewater facilities for 5 to 7 days, which would give us time for an injunction. I think A2 unions, the code anticipates that there will be an injunction, right? That there will be, that's why there's a difference between A2 and A3s, is because certainly A2s do not rise to the level of police and fire, and the stoppage of those services, they are at intermediate level, and there is a plan in place, and I think similar to the port, right, where if services were stopped, there is some period of time that we could run those services and get an injunction, and a court, the idea being that a court makes some determination as to whether that's the case. And I will say that our code is completely consistent with the state code and how the state code funds those services and national standards. I think across the nation, police and fire are generally in binding arbitration and not allowed to strike, whereas utilities, those kinds of services are considered to be services that can be, where there can be a strike for a limited period of time, and then the employer gets an injunction and the strikes stop.
Can I ask a question? What justification would you have for an injunction? What would you be arguing to the court?
I think that they'd be arguing that they can be shut off for a limited period of time, but at some point, some shorter period of time than the A3 unions, that we would need to get them back in
Why would you need to get back in?
to start running the services.
Well, why would you need to run the services?
Well, there's only, I mean, so I don't know if it would be, it depends on the circumstances. I don't know if it'd be emergency, being like contractors to come in and cross, right? Like it could become wildly expensive. It could start to hamper the operations of the facilities, those kinds of things. With fire services, with police services, we can't get contractors, right? Those are not services where we have available contractors. We also have there's no emergency plan in place for when you have no 911 dispatchers, you have no officers on the street, you have no ambulances running. That within minutes, right, becomes a problem. That is not the case with our utilities. They're very important essential functions for sure, but I don't think it's true to say that you can't limit the services for even a minute. We have emergency plans in place for several days can go by before we even anticipate seeing a problem.
Do you have
So-
some follow-up? Go ahead, Mr. Waddleton.
Yeah, okay, so, and I understand that's the situation, but didn't we, when they tried to go on strike, they had an injunction immediately? It wasn't like, okay, we'll call you back in a week. I mean, so you may have a strike time, but the reality is you can't strike.
Well, immediately, by the time you make the court filings, by the time the judge rules, you're clearly a week into it, right? Like you're not immediately getting an injunction. You file immediately because it's gonna take days for that to happen. And we anticipate that that's what's gonna happen.
Chair, this is Deanna. Can I say one thing about that former lawsuit?
Yes, go ahead, Ms. Ennis, and I just want to note for the members, I have Mr. Constant, Ms. Zalatel, and Ms. Allard in the queue. Go ahead, Ms. Ennis.
Just one quick response. I believe in that former lawsuit, AWWU counsel, or excuse me, the union counsel had actually stipulated to not strike, or stipulated to the injunction, one or the other.
Heidi, can you speak to that at all?
Ms. Dragic?
Yes, sorry, that's correct. Yes, sorry, I was on mute. Yes, that's correct. The union counsel at the time stipulated to it because the union agreed that the employees could not safely go on strike given the nature of the work that they were performing with the utilities. So there was an agreement reached beforehand to agree to the injunction for the reasons that we're here today.
Mr. Waddleton, did you have any further follow-up?
It's hard for me to keep up with the attorneys because I think there's a lot of depth to every word they say. It's like, I don't know what that means legally. Okay, so they did an injunction, but it was right away because the union had recognized that they are critical and can't strike. So on their side, they're saying we are critical, but the city's not so much.
Ms. Christensen?
Thank you. Through the chair, Mr. Waddleton, you file an injunction right away, but the anticipation is there's gonna be several days before anyone's gonna rule on it. We may get it, we may not, right? But I think that the code takes that into account. If the port employees were to strike and supplies stopped coming in, we'd file an injunction right away, knowing that it could take 5 days, a week, even longer to get an injunction. We know by that point that we could be running into problems. But that lag time is built into the procedures that are already in code, because we understand that that's the way that these intermediate services, that's what's gonna happen. And so I think if the police and fire services, APDEA or IFF were to go on strike, an injunction 7 days later, I mean, I think that most everybody would agree people will have died, crimes would have gone unanswered, violence would have occurred, heart attacks would have happened, and nobody would have responded, right? It is a different level of health and safety concerns. I will also say, from the administration's perspective, that the tiers are tiered as they are because binding arbitration basically gives a blank check to an arbitrator that we have no ability to contest or to change, right? So our processes generally start with a base understanding that elected officials are primarily responsible for approving the expenditures of public funds. And we only delegate that authority, the authority of an elected official to be accountable to the public in very rare circumstances when it's absolutely necessary. And binding arbitration is one of those circumstances, right? So the code anticipates that the assembly is responsible for ultimately approving contracts and for approving that expenditures of millions of dollars of funds, whether it's ratepayer funds, whether it's general government funds, whatever the funds are. And by going to binding arbitration, there is no elected official oversight. There is nothing the elected body can do. If an arbitrator comes out and says, you know, the A1 union gets a 20% pay raise, there's nothing that the assembly can do to say, we can't afford that, we're gonna have to cut essential services. There's just, that is what the contract is, and then the assembly would just have to figure out how to get those funds from a different place, or to cut services, or to do something. And so I think it's really important to remember that binding arbitration is delegating this substantial responsibility of an elected body to approve public funds. And that should only be done in very rare circumstances.
Thank you, Ms. Christensen. And I've got a number of folks here in the queue. I'll go to Mr. Shabaka, and then I want to go through the list. And I know there are some other folks from different parties who'd like to speak as well. So Mr. Shabaka, and then we'll go through the list.
Thank you, Chair LaFrance. Nikki Shabaka, Chief Human Resources Officer. I just wanted to echo something that, excuse me, that Ms. Christensen just said. So as it relates to the ability to strike, just if I can just say it a little differently, the code says that they should be, these are services that may be interrupted for a limited period, but not an indefinite period of time. What the injunction does is help make sure that provision stands. So if you are able to strike for 5 to 7 days or more, that is a limited period, but not indefinite period of time. So what this does is it enables the employees to strike, and the filing of the injunction immediately to start the process of consideration of the strike allows us to make sure, ideally, that there is a definite period at which the strike will end. So it's actually making sure that when she says this anticipates what the code, is trying to do, this is a way of actually making sure that we enforce the limited period of time side of it. It's not a way of trying to shut down the strike so that it never happens. And that's why she's saying that this change isn't necessary, because they are being able to strike, therefore they don't need to go to binding arbitration. Thank you.
Thank you, Mr. Chewbacca. So I'm going to go to Mr. Constant, then Ms. Zelatel, then Ms. Allard, then Mr. Dunbar, and then also Ms. Dragus and Mr. Mcguire. So Mr. Constant?
Thank you. Series of questions. Will the court always find that they can't strike? Is there a history of lawsuits in the Muni or in other jurisdictions in which the strike was allowed to proceed other than as quickly as you get the paperwork filed and whatever procedural time it takes to get to a decision nationally or locally? how long does an injunction last? Like, is AWWU still enjoined? And then what's the status of their contract?
And those are two.
The team.
Could also be the Mr. Dragons.
Through the chair, is there always a finding to enjoin the strike? I would say the only time we've ever asked for an injunction that I know of is this case in 2011. So prior to the sale of MLMP, we also had AWWU that was part of a utility. We have the port. We've always managed to come to contracts with all those unions and never had an issue. This was the only time that we had ever even asked for an injunction. So I don't think it's a very common place situation. I think for the most part, the municipality tries to come to an agreement on a collective bargaining agreement and not go to arbitration. It's certainly always my preference. And then, sorry.
How long does an injunction last? And is AWWU still enjoined?
No, they're not still enjoined. We've had a contract since the 2011 one. We've had two contracts since the 2011 one. We've had the one that would have expired in 2019. We went to arbitration on that one too. They chose not to strike. We went to arbitration. It went to the assembly. The arbitrator's decision was not approved by the assembly, and the union didn't strike. We didn't even have to go through the process. So they accepted the last best offer. And then we have this contract that we currently have, and that was through mutual agreement that came to the assembly for approval. I'd also say that any union in an A2 or A3 status always, the option of getting the arbitration decision is always available. It just takes a vote of the assembly. It takes 8 votes of the assembly to ratify that arbitrator's decision. So that is always an option available. They just have to get the required number of votes from the public officials who are responsible for evaluating that arbitrator's decision in the context of the whole municipality. So, and then, sorry, Mr. Christensen.
No, I think that covered it, but there was one question. It's really the national, is this a standard nationally? And I think maybe Ms. Dragas could help me with that.
Why don't you, Mr. Constant, can you repeat
Absolutely.
your question specifically? What am I responding to?
Yeah, fair. It started with, will the court always find that the union can't strike if an application for it to be enjoined is accepted? What are kind of the former status of lawsuits? I think we heard that answer, but really it's a question of, nationally speaking, is it a standard that water unions and other primary utilities have or can't strike, kind of have this A1 protection or not? And I think it's kind of just help me understand the lay of the land outside of Anchorage for these issues.
Well, I think municipalities treat it differently depending on the circumstances. So it's pretty, fact intensive. And so I can't speak to other municipalities, but what I would say is that we can't predict the future, but I think it seems a logical conclusion that were AWWU employees to go on strike again or vote to go on strike, the MOA would more than likely seek an immediate injunction. I think what Ms. Christensen described is everyone's preference. It is everyone's preference to reach an agreement. Striking is a last resort economic weapon, and what it does is that even the threat of a strike or the threat of imposing a last best offer creates a balance of power between the parties. And that balance, we're out of balance right now. So in that last injunction in 2011, the muni itself said that the safe time period to operate the water and wastewater utilities is non-existent, was the term that they used, less than 48 hours, which is why the judge in that case issued the injunction. So the parties basically understood there is no lag time. So that is not a meaningful right to strike.
Thank you.
And that is why we are here.
So I would just, last note on this for myself, in the news this last 2 days, of course, is the kind of nightmare scenario happening at the Sullivan Arena. And as it needed to happen, change had to happen. But what's the biggest complaint we've heard? There's no water for people, there's nothing to drink, and they haven't showered for 6 days, and it's a disaster. So everything else to me that I heard coming out of the Sullivan Arena to be managed. Vomit in the corner, that can be cleaned up, but the fact is people who can't go to the bathroom, they have locked portable bathrooms, right? They have to figure out a way to unlock the toilets immediately and get water so people could live, to me, strikes against the argument that this is not an absolutely essential issue. And so I just want to characterize this whole conversation in a very short-term context of what we heard about from the arena. It's meaningful to me.
Can I offer you,
Go ahead, Ms. Christensen.
just so that you guys have this, AS 2340-200 is the state statute that is the companion to our code provisions, and they read exactly the same. Utilities are classified as what we classify as A2 unions. And I think that to address Mr. Constant's comment, I don't think that we anticipate that people strike and the water goes off immediately, right? We have a plan in place where people are continuing to run the water and wastewater facilities. It's not like people strike and then you go to your faucet and you turn it on and no water comes out. And so that might be what's happening in the Sullivan Arena for a variety of reasons, but that is not what happens when the union goes on strike, just so that we're clear. And so in the state of Alaska, we follow the same standard as the state of Alaska does. And my knowledge across the country, binding arbitration is generally reserved for firefighters and police across the nation. It's just the general standard.
Thank you, Ms. Christensen. And I want to go ahead and move through the queue, and I want to hear from Mr. Mcguire as well. Ms. Zelatel?
Thank you. So just a couple of quick thoughts. If the sponsors are looking for a potential committee to hear this, I would have to check with the chair, but as vice chair of the Health Policy Committee, it seems like a public health and safety issue and something we might be able to hear. And we are the first Wednesday in October, if that timing works. With regard to some of the comments about the timing here, I'm a little concerned that the municipality would go immediately to get a preliminary injunction where they have to claim irreparable harm, knowing the irreparable harm is coming if, in fact, these individuals are allowed to strike. I think that really, whether it's a, 1 minute, like was mentioned around police and fire versus 1 week, seems like we could avoid that by changing this classification. I acknowledge that it's not within the maybe how it's happening nationwide, but if we acknowledge from the outset, if we go to court, we're going to seek a preliminary injunction that would either stop any potential strike. I don't see a meaningful opportunity to strike if that is really a piece to this, because the irreparable harm is the threat to public health and safety. And I kind of feel like I'm a bit on a hamster wheel with the arguments. So I just wanted to see if there is any thoughts about the fact that we claim, there's this, we're going to get an injunction right away, yet we are willing to, or we're unwilling to change this classification. I'm finding an imbalance there of those two things. Sorry, that was a long way to get to my question.
And Ms. Zelatel, I assume you want the administration to address your question?
Yes, and then if Ms. Dragas has any thoughts when she comes up in the queue, I welcome her thoughts as well.
Thank you, Ms. Zelatel. Ms. Christensen?
Thank you, through the chair, Ms. Zalatel. So again, I think I'm echoing what Mr. Shabaka said, which is the code anticipates 3 levels of classifications. One in which the services cannot stop for even a minute, which are the police and fire services, and then an intermediate level in which those services can be, the employees can strike and those services can be limited can be, there can be a limited stoppage of those services. And so I think the issue is we get a preliminary injunction right away because that intermediate tier, we anticipate it's going to take a week to 7 days to get an injunction, which I think is what the code anticipates is that intermediate level. I think that it would happen if the employees at the port went on strike. I think it would probably happen if some of the employees at solid waste services went on strike. That's what that entire intermediate level of unions is anticipated to be. And I think this is the standard. This is a standard in the state code, state statute. This is the standard kind of across the nation, that there are services that you can stop for some period of time, but it cannot be indefinite. It's probably going to be a short window. If a short window is 7 to 10 days. Again, I think police and fire services, we couldn't even stop for a minute. And those are why those are classified as an A1. And again, the idea being that a binding arbitration decision is without any elected official review. It's a spending of a massive amount of public funds with no accountability for a public process or a public vote or a decision by anybody who's accountable to the citizens of Anchorage. You should only allow that spending of public funds to be done by somebody who's not accountable to the voters, to the citizens, to the people who have to pay that money in very, very rare circumstances, because you are giving an arbitrator a blank check and there is nothing that we can do about it.
Thank you, Ms. Christensen. Ms. Dragus and then Mr. Mcguire.
The one thing that I think is important to note is that the municipality is on record in its motion for a preliminary injunction back in 2011, where it said that time period is extremely short, so much so as to be non-existent, a maximum of 48 hours. So there is no week or 10 days that we're talking about. And I don't think anybody in that room probably agrees that the water and wastewater utilities can be safely operated without employees for a week to 10 days. The time period does not exist, which is why it is, and I hear what Blair is saying, that you only want to make these decisions when it's truly important. There are public policy reasons to do so, and those exist here. This is a situation where workers do not have a meaningful right to strike. And so usually fairness dictates that the union should have binding arbitration. And binding arbitration isn't leaving things up to the whims of random justice. I mean, these are, neutral arbitrators, and then also mediators, because there is a mediation step before that, who look at these issues. Anyway, I think that was the one comment that I would make to that.
Thank you, Ms. Dragus. Mr. Mcguire?
Thank you, through the chair. And Heidi touched on pretty much everything I wanted to say, but I do want to touch on the argument of whether or not, if this did go to arbitration, that this could be something the unions could somehow get a windfall. And what I would say was, there's nothing also preventing an administration from coming in and having its negotiators at the table come in and cut everything and drop wages. Because at the end of the day, if we don't get at least 8 votes at the assembly level, we will fail. We will not be able to go on strike, because we know that our services are that important. Again, the community said it in their own 2011 injunction. They said 48 hours, but really and truthfully, they doubled back multiple times, and it's in the injunction. I'm happy to send that to everybody. That a strike for any period of time would pose imminent risk of health and safety to the public. And I'm going to go even farther. God bless police and fire. They do keep us safe. That being said, if you have no one at the control room working in your treatment plants, whether it's the water treatment or the waste treatment for 5 to 7 days, you actually pose a risk that could last a lifetime for hundreds of thousands of Anchorage residents, because the water doesn't go straight from the lake, straight from the source to the tap. There's a lot that happens in between, and it also doesn't go straight from the toilet or sink into the water. There's a lot that happens in between. And so oftentimes we don't think about the waste. We only think about the supply of water. But Assemblyman Constant touched on it when he said that people can't go to the bathroom. That's equally important, because we send our waste out in the water in our inlet. And that waste is pretty much as clean as you would need it to be able to drink it. Now, I'm not going to test that theory, but that's what we do. And if we don't have somebody manning that control operating room as well, the implications could be even further than just whether or not we get good drinking water. Thank you.
Thank you, Mr. Mcguire. Ms. Allard, you're next in the queue.
Thank you. So I'm hearing what you're saying. I'm hearing both sides of this. Are you saying that arbitration could be detrimental to our community without the community having a voice?
Yes, I think that is, through the chair, Ms. Allard, that is what I'm saying. I think that our process, our government anticipates, for the most part, public funds should be spent in an open and in public process. And that should only be that this body, you should only delegate your authority to approve the spending of public funds in very rare circumstances. And by giving another union binding arbitration, you are delegating your authority, your oversight, all of that of the spending of public funds to a person who is now unknown, probably not from Alaska, right? Probably somebody from the lower 48, doesn't know anything about the municipality situation, the funding of the municipality, what decisions are going to have to be made to deal with that arbitrator's decisions, what services would have to be cut, all of that would happen.
Can I just do a quick follow-up?
You can, yes, and then Mr. Mcguire would also like to respond.
Go ahead, and then I'll follow up.
And I'm not a lawyer, but I find it hard to believe that you wouldn't explain those things at arbitration. That's the point of arbitration, to explain the gravity of what both sides are wanting. And so I would like to think, number one, I know as a representative, and my boss as a representative of the workers at the municipality of Anchorage with AWWU, are not going to come in and ask for a windfall for our members. In fact, we moved just in 2019 to amend the Assembly's collective bargaining resolution guidelines, but those guidelines are still in place. And we don't intend on circumventing them or trying to eclipse them in what we're asking for at the negotiating table. This is about fairness. So, but to go further, if you're sitting at the arbitrator's table, the whole point of each party is to explain why you are seeking what you are seeking. And I find it hard to believe that Ms. Christensen, being one of the best, if not the best labor attorneys in the state, couldn't articulate why we were asking for too much to an arbitrator.
Thank you, Mr. Mcguire. Ms. Allard?
Yeah, so my follow-up question, and you can respond to this as well. So generally before they strike, any unions, they generally give you kind of a little bit of heads up that it's coming down. So at that point, they can talk to you and give you a heads up on it. But my take on this is the impact of ignoring the majority or a small majority that might not be getting what they want, but they still do have the ability to speak to the municipality of what may be coming down or what they want without impacting the entire, technically we could impact the state. Because what happens in Anchorage, we all know rolls over. So you could respond to that, but the community would absolutely be completely impacted without a say or a word.
Through the chair, Ms. Allard. That is correct, and certainly to speak about what Mr. Mcguire just said, certainly in arbitration, a portion is the finances of the municipality, but some idea that we're going to have a hearing in which there is going to be an ability to present evidence on all the impacts of this and certainly I don't know what those impacts are because I don't get to make those policy decisions, right? When funding gets spent and hard decisions have to be made, I don't know what those decisions are going to be. So we can certainly say, this is what our budget is, this is what we can afford, but to be able to present evidence that says, this is the implications of a 20% pay raise, I don't know what those implications are. I don't know what that means, right? I don't know if, because some of these, approximately 20 plumbers are in other departments besides AWWU. I don't know if that means that there's gonna have to lay off some of those employees. I don't know what those implications are. So some idea that that evidence could be presented in arbitration, I think, is not realistic. Those are tough decisions that generally elected officials should make, but an arbitrator, once an arbitrator makes that decision and that money is spent, you don't get to make that decision any longer.
Can I, Madam Chair, is it okay if I ask Mr. Mcguire just a quick question?
Sure, go ahead, Ms. Eller.
So I understand where you're coming from and I respect that. My question to you would be, have you ever gone before a strike has happened and done any type of talking to the municipality or anything? I mean,
We have
this
to.
is calming,
We have to
correct?
give notice.
What's that?
So we can't just go on strike. We've got to give notice. And so
Okay.
even in 2011, we gave notice, and that's when the municipality immediately moved to file the
Right.
injunction.
But you can talk to them and say, hey, we want this kind of, can you guys
Oh,
look
absolutely.
into this?
Not only can we, not only did we, but we have to. We have to.
So you do have that, I'm sorry.
Yes.
So you do have, I'm trying to get you, so do you have that opportunity? And the answer is yes.
Yes, ma'am.
Okay,
Yes.
thank you,
Thank you.
Thank you, Ms. Aller.
thank you.
So I have Mr. Dunbar and Mr. Constant, and then Mr. Waddleton. Did you have a question on this, or?
No, I can go around.
Oh,
Thanks.
okay. So
So-
Mr. Dunbar.
Well, I think that and forth is really interesting. I think Ms. Allard's exactly right. She's flagged something really important, which is that the plumbers have to go to the municipality first to give them some lead time. And that's precisely what the municipality is weaponized against them. Because as soon as they know what's going to happen, they go to the court and they get a court order that prevents them from striking. That's the fundamental unfairness here. And because we have contradicted ourselves, we are going to stop them. And we know we're going to the next time too. So I'd also I want to ask a question of Mr. Dragus and Mr. Mcguire too. I mean, ultimately this is a work session, not a debate, right? We're trying to collect information here, but I do sort of find that categorization that Ms. Christensen used of arbitration is sort of misleading for much the reason that Mr. Mcguire said, which is, again, it's not like some arbitrary person. It's somebody who has deep understanding of these issues or develops a deep understanding of these issues. And I remember when was it 2016 or 2017 when we had that vote, there was non-binding arbitration, right? I remember we took a vote on this and I was like, I remember being puzzled by it. I'd never heard of such a thing. I was like, non-binding arbitration, what does that even mean? And the arbitrator said, basically, you are categorically being, and this is my question for you, Brandon, if I'm miscategorizing it. My reading of it was, the arbitrator said, like, you have systematically sort of underpaid certain people in this area. And so we are going to ask you to increase the wage. And based on, other cities and other industries, or the people in the industry rather. And the arbitrator said, yes, the union is right in this case, not in all cases, but in this case. And then it had to come to the assembly, and it was just sort of funny. I mean, I think it got a majority, but not a super majority. Is that right? So it got 6 or 7 votes. And I just think it's sort of remarkable, like, to be afraid of arbitration, basically, where the arbitrator said, this is what you should do based on all the evidence. And then, politics basically got in the way, and certain people decided to vote the other way. And so it failed. And then again, for Ms. Dragus, I'd like to describe what happened then. I think the last best offer was imposed on the union, which means that we had evidence. The best evidence we had before us was that we were sort of being categorically unfair to this union. But then we imposed through the sort of machinations of the law that it would be imposed upon them. Is that an accurate description of what happened at the last contract, or am I misremembering?
Mr. Dragus?
The last, Brandon might know this better than me as far as the different years, but I believe the last best offer was imposed in 2016.
Yeah.
Is that right, Brandon? Brandon's got a longer history than I do.
Through the chair, and I wasn't actually on that negotiating team, but that is correct. So when we negotiated in 2016, came to impasse, went through the arbitrage decision, that came down. It did fail the the assembly vote 6-5. And at that time, the municipality answered to the last best offer. And if we go back and we look at that contract, you'll see that the union didn't sign that contract because we were objecting to it, but we knew that we couldn't strike, and we knew there's really nothing we could do about it.
And then my follow-up question, first of all, Heidi, do you have anything to add to that?
No, I think that he summarized that correctly.
So my other guest question is, so, you know, Ms. Christensen, you described, you know, 20%, you know, salary increases, like really potentially really detrimental to the municipality. But we do have this tool available for police, fire, and medical services. So why have there been in recent history these kind of huge spikes for police and fire? And why is it acceptable to do there? To go to arbitration? Why does binding arbitration seem to have worked in that realm?
Through the chair. I don't know if binding arbitrations work. We haven't gone to binding arbitration with the firefighters and the police. And so.
Can I ask, why do you think that is? I mean, we have this really powerful tool, but we haven't had to use it in the case of the police and fire. Why do you think that is?
I think that we have very good relationships with those unions. And both sides are loath to go to arbitration, and we work very hard. But I do think that it adds a certain weight to, because there's no review of the decision. And so it puts the municipality in a different position than otherwise. Again, the assembly it was fully within the assembly's power to approve the arbitrator's decision from both 2011 and 2016. The will of the body was not that. And I can't say why that happens, but it didn't happen. And can I just make a comment about weaponizing through an injunction? Just to be clear, I'm not sure weaponizing 3.70110 contemplates injunctions. It says right in the code provisions that, you know, we can apply for injunctions. It anticipates that. It is a remedy that is anticipated. It was anticipated when this was written. It's always anticipated in those situations.
Is it anticipated before the strike even begins, or at the 7-day point or the 10-day point, the code?
No, so to be clear, I'm not saying we apply immediately because it's gonna take 7 to 10 days to get it. So I assume when the assembly wrote this, that 7 to 10 days was written in there for those 8 unions, right? And this idea, I think it was said that no one's at the control of the wastewater and the water utility during a strike, which is not true. That is not what the emergency plan says. There are people there. The management, they come in and they run the facilities. People are running the facilities during that 7 to 10 day period. It's not that all of a sudden the wastewater and the water treatment plants are empty and nobody's at the helm and water's not coming out of the faucet. That's not what's happening. And so I know I've said this several times, only in very limited circumstances should an elected body delegate its authority to somebody who's not accountable to the public. And this body should be very, very careful about when they delegate that authorty.
So I just want to call attention to the time. We've got 10 minutes left, and I know Mr. Mcguire wanted to respond, Mr. Burke wanted to respond, and I've got 4 members also in the queue, and I wanted to make sure that there was time for final thoughts. I don't want to cut you off, Ms. Christensen. Did you want to wrap up?
Well, the only thing I would say is that both the arbitrator's decisions were imposed costs that were 3 times what we typically have, the cost of the contract that we typically have for collective bargaining agreements. And so I think that is something that the body should think about, that an arbitrator could impose a contract that is 3 times the cost that we normally associate with a collective bargaining agreement, and there's just nothing we can do about it.
3 times the cost or 3 times the increase?
The increase to the cost,
There's
yes.
a substantial difference between what you just said and that. You implied 300%, I just want to make sure.
Right, no, I think you're right. That is correct. I'm sorry. That is correct. 3 times the increase to the collective bargaining agreement.
Thank you, Ms. Christensen. So I'm gonna go to Mr. Mcguire, then Mr. Burke, and then I'm gonna go to Ms. Quinn Davidson because she's not been in the queue yet. And then we'll go to Mr. Constant, Mr. Waddleton, and then Ms. Allard, and I'm hoping we'll still have a couple minutes. We can go over. I know people have other meetings, but Mr. Mcguire?
Thank you through the chair. I'll be quick. To imply that there's this 5 to 7 to 10 day period that the municipality has personnel that can run these plants is just not true. The licensing and certification required, they don't have enough bodies to be able to run those plants for that many days straight unless you want to have somebody that's sleep deprived and who hasn't left that building. They simply don't have the manpower to do it. And that's one of the reasons why the injunction worked. And also, I think that the reason why both parties in the A1 status, police and fire, haven't gone to arbitration is because both parties know that when you go in front of the arbitrator, it's a risk. And it's a risk that you could lose. And you work towards finding an agreeable solution to avoid arbitration, not to use it as a sword. Thank you.
Thank you, Mr. Mcguire. Mr. Burke?
Yeah, through the chair, Patrick Burke. I just wanted to respond to Assemblyman Dunbar. It's not, I don't know that it's fearing the arbiter. I think that you have to take a step back and recognize that our system favors the public processes, as Mr. Haberman would point out. And I think that you only want to bypass that public process in the most limited scenarios that you can find. And I think that when you're looking at the code, it's certainly, I mean, that the emergent type services are the only services in which the ones where if we turn it off today, mayhem ensues, the city cannot run. And so you're saying, okay, in that scenario, we will bypass the public process and give the ability to an arbiter to do what ought to be done by this body. And we should only do that in very limited, narrowly tailored type scenarios. So I don't know that it's fearing the arbiter so much as it's not engaging in the public process. So I certainly don't want to couch that the municipality's position is, we fear a lower 48 arbiter coming in and, hitting us with some award. It's just bypassing the public process, I think, is the big issue. They're not respecting that we have a system in which we favor this body as opposed to an arbiter.
Thank you, Mr. Burke. Ms. Quinn Davidson?
Thank you, Madam Chair. I think that it makes sense that I'm following Mr. Burke because he just stated that this should only be a rare occasion, and I think it is, and that's sort of the point that we're trying to make here. And I just wanted to comment that philosophically, I take issue with what Ms. Christensen and Mr. Burke are raising. The idea that a politically motivated body who has all kinds of interests is better equipped to make a decision than a neutral third-party arbiter seems incorrect to me. So I feel that this administration just might be a little scared about what happens if we go to a neutral third party who says, oh yeah, you do deserve more for the work you're doing. So anyway, I don't see an issue with that. I think there's more some philosophical stuff going on. Thank you.
Thank you, Ms. Quinn Davidson. Mr. Constant?
So riffing off of that, Austin, I don't know that it's this administration fears it. I think every administration fears it. It's like, this is the age-old balance of the conversation, labor and capital, who's in control. And I want to say this conversation for me has been very enlightening. I think the most intriguing point is we have binding arbitration and it's never been used. And that conversation, or it has not by our police and fire.
No, that's not true.
Just not recently.
Right, that is.
Okay, within 10 or 15 years, okay. Then, okay, thanks for the clarification. Is very rarely used. And in recent history, it has not been used. Why? It was proposed because of good relationships, that people are loath to arbitrate because the risk is any side could lose. And nobody knows. And when you walk into a scenario, that certainly provides for you to be more fair and equitable, get to the middle quicker. With that in mind, what I really see here is that the problem is it, according to management, puts the municipality in a different position. That's a quote. Go back in the record to find it. Labor is arguing, yeah, it puts us on an equal footing for a conversation. And so that's just what I'm hearing. It may or may not be accurate. So that's kind of my takeaway. I look forward to hearing an alternate perspective from Ms. Christensen. But before that, what I haven't understood yet specifically is why we are here. Why is this before us now? Is there a specific problem that this is addressing, Brandon, that we can talk about in a concrete way? Kind of, we are here, or is this more philosophical? Why are we here?
Are you asking why now? Why are we now asking for
Why
this?
is this here now before us?
I can't speak for my predecessors who were at the negotiating table in 2011, 2016. What I do know is after 2011, we were caught off guard. In part because I think we thought at that time we won their arbitrary decision, it should pass the assembly. It didn't, and I think at the time, and I don't mean to speak for that administration, but they were entirely caught off guard. And so we said, okay, we're gonna regroup, we're gonna come back to the table again, which took a long time. 2016, we hit negotiations again. We went through the same process. And we certainly didn't at that time think that we would be faced with that same situation, that we won an arbitrage decision and it again failed an assembly that arguably at that time in 2016 was a more labor-friendly assembly. If we're just gonna call it what it is, it was a more labor-friendly assembly and it didn't pass. Following that, we started looking at this code change and how we could impact that change on behalf of our members, because that's what our members have been crying for since this has happened to them twice. Unfortunately, there were a lot of things that happened in between then and the next set of negotiations. SAP was a big issue, and this administration asked us a lot of favors during that time as far as allowing them leniences and not kind of coming full bore on many different aspects for which we agreed, and we extended all kinds of timelines. Another thing that we didn't want to jeopardize after talking with certain people was MLMP and the sale of MLMP, and our seeking an A1 status arguably might have brought forward an argument that and a settlement. If we had brought forward that argument then, it could have potentially entered the cell of MLMP. We held off to allow this body and the administration to complete that task without trying to throw a wrench in that. MLMP is sold. We are now at a point where we don't know what's going to happen in future negotiations, but we do know that there's nothing preventing an administration from coming in and cutting our pay. Not even giving us any increases, but cutting us going to arbitration. And if the legislative body at that time decides that we don't even deserve to stay at that same pay rate, if we don't achieve a super majority of what right now is 8, we will be forced to take pay cuts. And so for the same argument that we might come in and try to get way too much, we are going to argue that we don't want to lose way too much. And it's entirely plausible in the scenario that we are now sitting in.
Thank you, Mr. Mcguire. And so we're at the end of our time. Can people stay another 15 minutes? Can you all stick around? Because I'd like there to continue to be some dialogue. And we do have.
Before though, Ms.
Can we
Christensen.
yes, we're gonna go to Ms.
It's a work
Christensen
session, sorry.
next.
Yeah, it's not a committee.
It'll be on.
Yeah, so we'll go to Ms. Christensen next, but I want to let folks know that I have Mr. Waddleton, Ms. Allard, and Mr. Dunbar then in the queue. So Ms. Christensen?
I'm gonna defer to Mr. Burke.
I just want to, something on Quinn Davidson, you had a good point, and the point was something along the lines of, an arbiter can be a neutral, disinterested, more fair, adjudicator of an issue. The difference is that this body, the assembly, or the executive body are subject to the voters. And if the voters don't like what this body or the mayor is doing, they can change that in a matter of a couple of years. We don't get that option with the arbiter. And so while I do agree that arbiters can oftentimes be less politically motivated, not as politically charged as some of the represented officials, either in this body or in the executive body. The point is, the arbiter isn't subject to the will of voters.
Can I ask a really quick follow-up to that point, Milan?
Before, this is a response to my
Okay.
question. And I would just offer that it's an interesting perspective. However, we are still subject to being reviewed by the voters at a regular interval and for this action or any action. And so it might feel attenuated, but I don't think it's that attenuated.
Can I ask, Madam Chair?
Oh, and we
The phone
have,
lines have been cut off now.
we lost sound here. Okay.
That is a time issue.
Yeah, we need to figure
All
out, our new phone system must somehow be kicking us off at one.
So just hold that thought, okay, because we've lost 5 folks. Can we get the line back up, Desiree? And then, and it's my understanding that I don't need a motion to extend because it's a work session and that we can continue to go. However, if anyone wants to challenge the chair's ruling on that, that's always an option. They're asking if they call back in.
The number is still open, it's just this phone is dropped.
As someone calls, it gets cut off frequently. There's the lines, I literally will hang up, call back, hang up, and then I'm on.
Please enter your participant.
I don't know if it works.
Please say your name, followed by the pound key.
I'm back in, Madam Chair, if that's
Oh,
helpful.
great. Okay, so we've got Ms. Quinn Davidson.
Yeah.
Anyone else on? I'm telling people to please call back in.
Yeah, this is Pete. I'm back on.
Great, thank you, Mr. Peterson. How about Ms. Kennedy, are you on? Okay,
She's trying, she's coming
She's
back, she's
trying.
gonna call back in, she said,
Okay.
yeah.
okay, and Mr. Rivera's back on.
I haven't, Ms. Drungus, because she got kicked off, she didn't say if she.
Okay, so we have Ms. Kennedy. Are you back on, Ms. Kennedy?
She's out of town, I don't know if she's gonna be able to get back through.
Okay,
Desiree.
okay, so I've got Mr. Gates is back. Okay, Ms. Kennedy, is that you?
Yes, thank you.
Okay, so we're gonna go ahead and continue with the work session for about another 15 minutes or so, and
Just a very quick question, not while I'm in the queue, but we keep talking about this, like there's no way to appeal an arbitrator's decision. Can it not be appealed to the Superior Court for abuse of discretion, or whatever the standard would be?
It cannot, no. Only for very limited legal reasons, and I think
Okay, so
it's
it can
actually,
for very limited legal reasons.
right, but those reasons don't generally come up. Fraud, you know, well beyond the normal appeal rights. It's, it says in the code.
Well, why would it? Interesting.
So it's not like as a matter of course, the municipality can appeal it, like we can appeal any judgment. It's only for very narrow circumstances that very rarely arise.
okay. Thank you, Ms. Christensen. So we'll go next to Mr. Waddleton.
Yeah, so, I guess Ms. Christensen, so, I mean, if everything you say is correct, and I assume it is, and the various impacts, but when the plumbers are negotiating, it just seems unfair, because realistically, maybe they can go on strike for a day or 2 days or even a week, and that's it. So it's almost like they really don't have any balance, because I think that strike would hurt them more than anyone. So it's like, you know, if you don't agree with us, you can shoot yourself in the foot, but we're gonna give you this last best offer. I mean, how does that super short time to strike, which is somewhat hypothetical, how does that help them in negotiating? It's still in balance. The city has all the cards.
Through the chair, Mr. Waddleton, so that middle tier, which is more than just the plumbers, right? That's 302, Teamsters to the extent they're solid waste services, 302 at snow removal, I mean, all sorts of it. It's the same for all of them, right? That is that middle tier. That is, I assume, what the assembly intended when they passed the code, that middle section of unions, the A2s, have that limited ability to strike. They don't have the ability to strike that the A3s have. They have a limited ability to strike. And so I understand that in your mind it might not be long, but that is all the A2 unions. It's not limited to the plumbers.
Anything else, Mr. Waddleton?
No, thanks. I have to let it sink in and think through that, but thank you.
Ms. Allard?
Thank you. So, Mr. Dunbar, you brought up fundamental unfairness, and I wanted to think about that one because I would believe that fundamental unfairness would be that potentially the community is completely cut out. And like today, we are going through, I'll just bring it up, the mandates and forcing people to wear masks, and we all represent our communities. And through the arbitration, all those persons, 280,000 residents, can be left out, and we have a voice on the body. So even if we're out, we disagree on the assembly and mandates should happen or shouldn't happen, or emergency orders or anything us as a body decide, we are representing those people in our community, which means we do have accountability, even if it's tomorrow, even if it's a month from now. So my concern is that there's a point that the taxpayers should fear, not us necessarily, but the taxpayers and not necessarily the muni either, should fear arbitration because they're the ones that are gonna have to pay and they're not gonna have a voice. And to do that to the community isn't, in my opinion, is absolutely insane. I understand what you're saying about how important AWWU is and the labor unions, I get it. But we can function, and there are people that will step up in the source of an emergency if for some reason the unions decide, well, I don't agree with it, because there's a time period from the time we strike, I say we, but the members decide to strike, and then the time they need to come together to negotiate. And we do that because we do that for everybody involved. But I don't know. I'm just having a really hard time because I don't want somebody who has it's not from here, because that's potentially what could happen. Because if you have somebody in the state of Alaska, we're the size of cities in other states, to come up here and make a decision that can absolutely be detrimental to our community. When I know that it will be detrimental, I have an issue with that. But I'm trying to wrap my head around it all to be fair all the way across. Mr. Mcguire, yeah, absolutely.
Go ahead, Mr.
Chair,
McGuire.
thank you
Yeah.
very much. If what you were saying were true, we wouldn't have an injunction filed against us in 2011.
Can you
If the
speak
municipal,
just a little bit? Let's talk about today, though. I mean, I know you're bringing up 2011, but let's talk about if you guys went on strike, or you guys had arbitration.
the intent is to address what you had said, that if we did actually, we being the union members, did actually go on strike, that there were people who could step up. There simply weren't. There weren't then and there aren't now. You don't have enough bodies that have the required federally mandated licensing and certification to be able to run.
Army Corps of
plants.
Engineers would disagree with you.
I would love to see those numbers. I don't think that you have the required number of bodies to allow us to go on that limited strike period, even if it was only 5 days. And in fact, that's the exact argument used in the injunction to prevent us from going on strike, is that we couldn't strike, not even for 48 hours, because any strike posed immediate risk of health. And so I feel like we've gotten off track, and we're starting to get scared of this boogeyman that the union's going to come in and ask for this huge windfall. That's not what it is. We're asking for fairness. We're asking for fairness. That's it. And we don't have it right now. We simply do not have fairness at the negotiating table. And when you're sitting at the table and a party across says, well, if you don't like this, then we can go down the path because we all know the path. That's not fair. That's simply not fair when you're at the table.
Can I?
Go ahead, Ms.
Is
Allard.
it fair to do that to the community members if they don't have a voice? And you're literally, like me as a representative, I'm gonna block them out. That's it. You guys don't have a voice.
I believe it was just said that the community members have a voice all
No,
the
they will
time
not in
whenever they
arbitration.
vote. Correct me if I'm wrong. We vote in the body. The community members do have that vote.
Right, but here's what I'm saying. As soon as arbitration stands up, we don't have a voice anymore. One person makes that decision and all of our voices don't matter, except that maybe we voted to allow the arbitration to happen. After that, we're done. Is that not correct, Mr. Burke, or Crystal, if you guys can, if you Chris can answer that.
If I could just real quick to reply, please, through the chair. Welcome to how our members feel.
I can't hear you.
Welcome to how my members feel.
Welcome to how my district feels
Okay,
today, right now.
thank you both. And then quickly, Ms. Christensen, and then I'll go on to other folks in the queue.
Through the chair, just to answer Ms. Allard's question. I think that is a correct statement, that once, at binding arbitration, the assembly no longer has a voice. You have delegated your authority as an elected official to the arbitrator. That is correct.
Thank you. Thank you, Chair.
Thank you, Ms. Allard. Mr. Dunbar?
Thank you, Madam Chair. So I really like Ms. Allard's analogy of the
Are you gonna use it against me?
the legal mandate.
Here we go.
Because what we've done is,
Yeah.
so A2 exists in code, but this A2 category exists in code.
Right.
But when they tried to do what A2 says they should be able to do, the municipality went and got a court order to say, no, you must treat them like an A1. You must, the statement was immediately it was harmful. We're going to stop you before even 48 hours. So they could not have done it. They could not go on strike.
To limit this strike period.
Yes. No, they went even earlier. They didn't go on strike at all. And yeah, there were some stipulations there, but the municipality went and said it would be immediately detrimental and we need to stop it. So that's what the fundamental unfairness is. A2 exists in code.
Yes.
We, the municipality, have gone to a court and said, treat them like A1. And so what this does is say, legally treat them like A1. And I know Ms. Christensen is going to make a little distinction between, 48 hours versus 7 days and what have you. But ultimately, that's what we did. That's how I feel we did. But I have 1 point and then 1 question. 1 point is, I think something Ms. Christensen said implied that this was going to, there are AWWU represented employees that are in other parts of the municipality, like inspectors and stuff. This does not apply to them. That's not the intention of this.
It will. It will. You cannot separate the bargaining unit.
Okay,
So this will apply to the entire plumbers bargaining unit. You cannot split the bargaining unit.
That's ouch.
That's interesting. Okay, we'll have to talk and work on that. My intention is, I'll say it doesn't apply to, it certainly doesn't apply to them outside the municipality, but my intention is people that work in sewer and water treatment that are involved in those direct processes. So that's one thing. So Ms. Allard mentioned the Army Corps of Engineers. Are they part of that? Is that something that's envisioned by this emergency plan that we have in place, that we will call in the Army Corps of Engineers to run our facilities?
I haven't looked at the plan through the chair. I haven't looked at the plan recently. I think there's a variety of options. I think that the options envision management, non-represented employees running it for a time period. I think there are contractors that can run the facilities, unlike police and fire, where we don't have that option. I think I previously mentioned. So I think there's a variety of options. I'd have to look at the plan specifically to figure out what it said. And
the states, you can also go through the emergency operations. So with the federal side, there are different avenues to contract out.
I think it would be very difficult for us to go to the Army Corps
Difficult, but not impossible.
to go to the Army Corps of Engineers and say, you federal government, please federalize our utility because we have a strike.
And I have to interject here because we're again at the end of our time and have actually let this kind of get more into debate that is customary in a work session.
Some specific questions.
Okay.
Information for later, so if I can land
Yep, so the last person I had in the queue is Mr. Constant. So go ahead and then we're gonna need to adjourn.
Yep.
And we can have a second work session or committee discussion to take the rest up.
So it almost begs for a conversation about a fourth tier, like an A1B, or not. A1 might be the case. A question that probably could be answered pretty quickly. The question that I have about the arbitration decision being final, is that a state statutory federal law provision, or is it in the code that the binding arbitration is not appealable to the Superior Court? Except
it's appealable
for these limited cause, right? So
Right.
Is that in statute, code, or federal?
that is in your code. That's in the code that you guys are amending.
And so that's something that we could look at for future purposes.
Through the chair, you could. We'd have to do legal research.
Right, it's local. Thank you. Then I would like, and I don't know who can provide this, but a list of certifications and PCNs that are needed to operate so that we can adjudicate ourselves what the level of staffing would be needed in the case of a strike. So we can judge it's 48 hours we could operate for, it's 72 hours, it's a week, so that we can have a sense. And it doesn't have to be who's in those jobs or whatever, but what certifications, because we heard that mentioned here. And it would be nice to understand what the actual requirements are, because there's a tension between the two.
The chair, we'd have to do legal research because I believe during emergency strikes that those requirements would be lifted.
And so I would like to understand the
So we have
foundation
to-
of that.
Right, it might be more than just looking at the certifications.
Right.
It's also legal requirements of the emergency situation and who can operate in those circumstances.
Right, it's interesting, if emergency can be declared, I'm just done, if emergency can be declared, then it again pushes the balance of power in this conversation in an interesting way. And finally, for me, I think the fatal flaw is filing the 2011 to the courts, not even 48 hours. So I look forward to the next step in this conversation.
Okay, thank you, Mr. Constant, for those questions. Thank you all for being here today. We look forward to more discussion on this. We are adjourned. Sorry.
Good amount of time.
Kind of